rehearing for the We the People National Finals.
Recording in progress.
In a moment, the judges will introduce themselves, followed by the students, and then the hearing will begin. You will deliver a 4-minute prepared statement, followed by 8 minutes of judge questions. And I will be muted throughout, but I will hold up for reference a 1 minute and time sign. I would suggest using gallery view if you're not already. And at the end, the judges will provide you some brief feedback, and then we will conclude. So, with that, when the judges join, I'll hand it over to them. All right, they are on their way back. So, judges, they are all ready.
Excellent, thank you, Joseph, and thank you, students, for being here today. We are the judges for Unit 3. We're very excited to get this conversation started, but we'll briefly introduce ourselves, let you do the same, and then get rolling with the question. My name is Max Griffith. I'm an attorney in the Boston area, judge advocate in the Army Reserve, and most importantly, an alum of Unit 3, so very excited to be speaking with all of you here today.
Good afternoon, Unit 3 from Nevada. My name is Zalal Mbogala. I'm an attorney in the great state of Nevada. I'm also a professor at the University of Nevada, Reno, where I teach race, law, and criminal justice. I'm a former prosecutor and a former We the People alum. That's the most important part. I sat in your seats long ago in the national finals. Not your physical seats, but your figurative seats, of course. And I'm very excited to hear what you have to say today.
Good afternoon, Nevada. My name is Tom Fons. I am a professor at Kansas State University, and I've been doing We the People for 30 years now, more than 30 years. It was actually called I the Person when I first started, and I've enjoyed it for 30 years. I've been a teacher and served as a scholar, done all kinds of things, state coordinator, and I just really love talking about constitutional ideas with students. We're going to have a great conversation and make a great memory today.
Great, thanks, Tom. And students, if you wouldn't mind introducing yourselves as well.
Good afternoon, judges. We are Reno High's Unit 3, and we are coming to you from the University of Nevada. My name is Grant Yu, and I will be attending the University of Michigan.
Good afternoon. My name is Maya Bouvier, and I will be attending the University of California.
Good afternoon, judges. My name is Rachel Christensen, and I will be attending the University of Southern California.
Good afternoon. My name is Maya Stanley, and I will be attending the University of Nevada.
Good afternoon. I'm Natalie Mastic, and I will be attending the University of Nevada. Our unit coach is Mr. Matthew Oakes, and our teacher is Mr. Richard Clark.
Excellent, thank you very much. We'll read the question and then get started. Question number 2. The 14th Amendment and its grand ideal of equality under the law have meant no more than succeeding generations were willing for them to mean. To what extent, if any, have societal changes impacted the ideal of equality under the law? Is the legal analysis used by the courts to determine whether a government action violates equal protection of the law sufficient? Why or why not? When, if ever, is it permissible for the government to discriminate against persons or groups? Explain your position. You may begin.
This nation was founded by men of many nations and backgrounds. It was founded on the principle that all men are created equal, and that the rights of every man are diminished when the rights of one man are threatened.
In 1963, President John F. Kennedy addressed the nation about the ongoing civil rights struggle. Centuries beforehand, the founders diminished their promise of equality by blocking African Americans from their liberties through the 3/5, fugitive slave, and 20 years clauses. These scars in the Constitution were eventually nullified through the Civil War amendments, which reflected the societal change caused by the Civil War.
Kennedy continues, 100 years of delay have passed since President Lincoln freed the slaves, yet their heirs are not fully freed. This nation, for all its hopes and boasts, will not be fully free until all its citizens are free.
The decline of Reconstruction was marked by President Lincoln's death and heightened by the federal government's unwillingness to enforce the 14th Amendment. The civil rights cases of 1883 deemed the Civil Rights Acts of 1870, 71, and 75 unconstitutional, stripping Section 5 of the 14th Amendment of its power. The government reflected a bastardized version of equality through the separate but equal doctrine, which was established in Plessy v. Ferguson and strengthened in Cumming v. Board of Education.
Prohibition reflected the politicization of morality. and the ratification of the 19th Amendment showed a societal acceptance of equality for women. The Snyder Acts of 1921 and 1924 expanded citizenship to Native Americans, reversing Article 1, Section 2, and the 14th Amendment's exclusion of Indians not taxed.
Kennedy continues. This is not a legal or legislative issue alone. It is better to settle these matters in the courts, and new laws are needed at every level. But law alone cannot make men see right.
The levels of scrutiny were designed to settle the matter of equal protection in courts, but they do not have the enforcement power to protect these ideals. Therefore, rational basis, intermediate scrutiny, and strict scrutiny cannot make men see right without aid from other branches. Brown v. Board of Education had to be enforced by President Eisenhower to protect the Little Rock Nine.
The movement towards acceptance for the LGBTQ+ community, catalyzed by the Stonewall riots in 1969, led to greater equality under the law through Morris v. Texas and Obergefell v. Hodgson. However, these cases protect gay rights under the fundamental rights of privacy and marriage, rather than protecting the identity itself.
In Masterpiece Cake Shop v. Colorado Civil Rights Commission, immutable characteristics and fundamental rights came to a head, showing that the levels of scrutiny fail to differentiate between these two categories.
Kennedy continues. It is not enough to pin the blame on others. Our task, our obligation, is to make that revolution, that change, peaceful and constructive for all.
Individual sacrifices are necessary to promote the common good, but discrimination today should only be permissible as a last resort to promote fairness in society.
The levels of scrutiny are flexible enough to support both equality and equity through the Equal Protections Clause. Grutter versus Bollinger accepted the use of race-based affirmative action, while Gratz versus Bollinger clarified that the university needed to provide a compelling interest for discrimination.
Kennedy continues. We face a moral crisis as a country and a people. It cannot be met by repressive police action. It cannot be left to increase demonstrations in the streets.
Approximately 500,000 people today are incarcerated due to the inability to pay a fine. Transgender people still face unjust discrimination due to their gender identity. We must continue to redefine the ideal of equality under the law to fit society's current needs and bring society closer to true equality. Thank you.
Thank you very much. Just right off the bat, can one of you please just quickly run through for me the level of scrutiny and what the standards are?
The levels of scrutiny are strict, intermediate, and rational. For strict scrutiny, you need a compelling state interest. For intermediate, you need a foreign government objective. And for rational basis, you need a legitimate state interest.
And what groups are targeted by those levels?
So an example for strict scrutiny protects both fundamental rights and the use of race. For example, in Korematsu versus US, the Supreme Court ruled that the law was both narrowly tailored enough and that the country had enough compelling state interests to intern Asian Americans based on their race.
For intermediate scrutiny, these laws can establish gender classification, and you need important state interest to exist and be substantially related to that interest. So an example of this is Craig v. Boren in 1978.
For rational basis scrutiny, this encompasses everything else other than the first two levels of scrutiny. This can be seen in Stanton v. Stanton, and the legitimate reason for the government is that the age of adulthood for boys and girls were different in the state of Utah, and this was not allowed.
I want to ask about the example you use for strict scrutiny, and that Korematsu is often spoken of in a derogatory manner, yet it's the one that you held up as the example for the most exacting form of scrutiny. What's your opinion on the Korematsu decision?
We believe that the Korematsu decision is inherently wrong because the U.S. government only discriminated on the basis of race, and as they did not intern German or Italian Americans, only Asian Americans.
Furthermore, this court case has been sort of overturned in the Supreme Court case Trump versus Hawaii, and so the court has apologized for the egregious decision that was made in Korematsu versus U.S.
I want to I do want to ask one quick other question because you've answered that quite succinctly, and thank you. So, with respect to money, taking it a very different direction, can we really have equal justice under the law when the wealthiest people can buy the most effective counsel in court?
Public defenders on average can spend about 25% less time than a paid defender would be able to, and as such, this means that they are physically unable to provide the same amount of advocacy for their defendant as they would be able to if they were paid.
However, the Supreme Court case Gideon versus Wainwright did establish that if you are unable to provide an attorney for yourself, the state will do so, as everyone has equal access to their fundamental rights.
The Supreme Court also ruled through San Antonio Independent School District v. Rodriguez that socioeconomic equality is only a given rational basis.
Okay, thank you. I want to make sure we move on to the other questions.
Thank you, Max. Great testimony, and I want to kind of pick up on something you said in it. So you made a distinction between equality and equity, and let's jump to the heart of that. Should governments be able to use race in particular, in order to promote a historically marginalized group or to make up for past societal discrimination? And what does the Equal Protection Clause have to say about that?
They should be able to, as we can see in our testimony for Gratz and Greta v. Bollinger, they upheld the use of race-based affirmative action in college admissions. However, in Bakke v. the State of California, it was clarified that they cannot use quotas and it can only be a plus factor.
Right, and I'm going to stop you there before someone else jumps in. In those cases you mentioned, which are great, the compelling interest there was diversity in education. I'm talking about remedying past societal discrimination as an equitable principle. Should governments be able to do that? And what does the Equal Protection Clause have to say about it?
They should. An example of this can be seen in the Ninth Circuit and Bonk decision in Brooks versus Beto, in which the courts ruled that it is constitutional to purposely include someone on a jury based on their race in order to make up for past discriminations of leaving certain races off of a jury.
Additionally, in the Fifth Circuit decision of Rakim v. Harlan, it was established that the Indian Child Welfare Act of 1978 was constitutional, and this act discriminated on the basis of race, that Indian children should be adopted to families that were also Native American.
Thank you very much.
So let's take the line of questioning a little bit different direction. We've been assuming that equality is always good. Let's turn that on its head. Is it possible that we, either as a society or as a government, take the ideal of equality too far? And if we did, why would that be negative? And if we can't, why not?
Absolutely, the idea of equality has been used in the negative light. For example, in the California Supreme Court case, Serrano v. Prius, the court ruled that a blanket income tax on every resident for the same amount was unconstitutional and violated the Equal Protection Clause because the people with lower income were hurt so much more than the upperclassmen.
In many cases, however, we've seen that equality isn't enough to make everybody have equal opportunity, which is why we use equity. For example, in 1910, Oklahoma amended their state constitution, adding Article 3, Section 4A, known as the Grandfather Clause, which disproportionately impacted people of color's ability to vote. And this was overturned in the 1915 Supreme Court case in the United States, and it declared that it was a violation of the 15th Amendment and not the 14th Amendment. So even the use of equality in this instance wasn't enough to protect every citizen.
There are problems sometimes with the level of equity and equality that we strive for. For example, with affirmative action, the state of New York has actually categorized Asian Americans and white people in the same category. And so this has shown that there are some downsides to things such as affirmative action.
So would it be better, just as a follow-up to affirmative action and kind of my question, would it be better if we had, would you prefer as a citizen that we had affirmative action based upon class, based upon economic status rather than race? Would that be preferable?
I don't think it would be, because as a white person, I can walk around every day not worrying that because people look at me, I'll be treated lesser than, or because if I walk into an interview because of the color of my skin, I'm less likely to get a job. And although socioeconomic status is important to consider, I'm able to hide my status and there are resources available, whereas for a person of color, it's visible to everybody that they could be treated as less than when they absolutely shouldn't be.
Additionally, African American people are 5 times more likely to be incarcerated than their white counterparts, which shows that there is a racial bias that is not purely socioeconomic, but is based on the color of these people's skin that makes police target them, and also the justice system to also further target them.
I disagree.
Oh, sorry, we're out of time. Rachel was getting ready to disagree.
But thank you very much. Great job, everyone. Right now. Very, very well done. I'll just go through a couple comments. I thought your opening was great. Had a nice, strong start right out of the gate, Natalie. Well open. Just it really sort of set the tone for the rest of it. Good job there. I like the reference to the civil rights cases. That's a part of history that often gets overlooked in this unit, and it was it was a good pull, I guess is the best way to say it. Nicely done. I liked the argument about the levels of scrutiny lacking enforcement power. So you're sort of using it's kind of parallel to the argument about the court lacking its own enforcement mechanism, right? And drawing on Broadby Board and state pushback to that as a way to show it. I thought that was a really clever way to criticize the levels of scrutiny from sort of a practical perspective, and one I haven't seen as much, so nicely done there. For the follow-up, good job. Just, you obviously know the levels of scrutiny, knocked out of the park. I wonder, and I don't know if I think this or not, I wonder if that had gone into your opening statement, we would have had time for follow-up on a wider variety of topics. You clearly knew it though, and you answered the question perfectly. So nice job on that. The answer about economic disadvantages in the court system, it's a tough, kind of tricky question. I like to think it's hard to answer and give solutions for. I like the statistic about public defenders having X% less time, pivoting to Gideon, talking about the right that we do have to counsel, and I really like the reference to the San Antonio case and about, I think you were saying income as a rational basis standard, really, really nice way to bring in the levels of scrutiny to that argument. Nicely done there. I would have liked it if you had sort of taken that big open space of civil cases, right? Because Gideon is criminal, we're talking about criminal, but civil cases occupy most of what any of us will experience when we encounter the court system in our lives. And so there is no Gideon for civil cases, and one wonders if there should be, because housing falls under civil cases, for example, right? There's a lot of rights that people would presume to be fundamental in some ways, but they're not in the criminal context. So just something to think about. I would have liked it if you had taken me there, but that's just, we're talking about, you know, cherries on top of cherries. That you did a great job answering the question. And I won't drag down the conversation anymore with other stuff, because I would only be saying good things. So nice job, and on to the next person.
Thank you very much, Max. Wow. So look, you've impressed someone like Max, someone as intelligent as Max. You've done a good job, and you clearly have. That was impressive. I close to speechless, but I will try to speak. So, using that JFK quote to interweave and attach different historical occurrences was a cool rhetorical way of handling this question. Very sophisticated way of presenting, and I noticed it and I appreciate it. In terms of the substance, you know, to Max's point, not just the civil rights cases, but you mentioned all the civil rights acts of the 19th century, which are not often talked about. People talk about the Civil Rights Act of 1964, but not too often do they talk about the Civil Rights Acts of the 19th century, so very important. Both Snyder Acts as well, and really, you know a team is really good when they sort of anticipate what the judges might ask them, and you did with my question about equality versus equity. You touched upon it in your testimony, and it pinged for me to bring it up during the follow-up, and I thought you eventually got around to answering it incredibly well. I mean, I started hearing that Ninth Circuit case that I've never heard of before, a Fifth Circuit case I've never heard of before, and just deep sourcing for your responses, which was highly impressive. And I mean, to go further down that line, a 1910 revision to the Oklahoma Constitution that was then later overturned in a specific case again, which I've never heard of before. And again, I'll just remind you, I am an attorney, I promise. Hadn't heard of that case. So just the amount of source material here was prolific, and I was very impressed. So very good job.
Yes, I concur with all of those things, although I want to exclaim maybe even a little bit harder on a couple of points, and I hope your teacher is on and listening. We tend to only focus on, we the people on the Supreme Court, and we forget that there's a whole bunch of other courts out there who are interpreting things for us that influence the way that we live and interact with one another. So kudos to you and your class for citing not only circuit court decisions that we've never heard of, but also state court decisions. And I love that. You know what else I love? You know what else I love? And you're the only class that has done this so far, that you come right out and say, yeah, we know all of this. We know all the levels of scrutiny. We know circuit court cases. We know obscure state court cases. But we also know that it's not just the courts that are responsible for all of this. We have a couple of other branches, you said, that are also responsible for ensuring equality or for messing it up too. And you're the only team that I can remember that has said that. And again, being able to weave in all of that stuff, plus kind of some more obscure thing. Section 5 of the 14th Amendment. Again, kudos to you. Who mentions that? The civil rights cases, almost in the same breath. I thought that was great. On my particular question, I was hoping that you would go a little bit further with, lesson 39 in the We the People text is, I think, a beautiful one, a great one, that says basically, any one of these values, principles, ideals that we hold dear can be taken to some sort of extreme that's not good. And equality's in that boat. Equality has to be balanced with all of the other stars in our constitutional constellation, right? And so I was hoping to hear a little bit more about that. I mean, you did go to at least the political process, but it was a noteworthy, stellar performance, and you should feel really, really good about where you're at. Thank you so much.
Thank you.
Recording stopped.
Oh, we do have a big.
Mr. Clark and Mr. Oaks.
Fantastic.
Teachers there, some great teachers.
Excellent. Excellent. Wow.